In 1871, the British colonial government of India conducted the first comprehensive census of the subcontinent. It counted 238 million people. It recorded their religion, their caste, their occupation, their language, their age. It was a triumph of administrative precision, the largest demographic survey ever conducted in Asia at that time. And in the same year, using the data that census produced, the colonial government passed a law, the Criminal Tribes Act of 1871. Under this law, more than 200 communities across India were officially classified as criminal, not because of anything they had done, but because of who they were, because of the community they were born into, because of the name their parents gave them. You were not convicted of a crime, you were registered as one. Adult men in these communities were required to report to the local police every week. If any member of a notified community was found outside their designated area without written permission, they could be arrested, not for what they had done, for where they were, for who they were. Children born into these communities were separated from their parents and placed in reformatory settlements, not because the children had done anything wrong, but because their birth had made them, in the language of the law, hereditary criminals. The language of the law was precise: hereditary criminal, criminal by birth, not accused, not suspected, not convicted, classified. At the time of Indian independence in 1947, 13 million people in 127 communities were living under this classification. The law was repealed in 1952. The classification was not. Today, approximately 60 million people in India belong to communities that carry the administrative legacy of 1871. They are called denotified tribes, the tribes that were denotified, removed from the list. But removed from a list is not the same as removed from what the list did to them. The census mapped India. For more than 200 communities, the map marked them as something that did not belong on it. Here is what the history books tell us. The Criminal Tribes Act was a response to a real problem. After the rebellion of 1857, the Indian Mutiny, as the British called it, the colonial government was concerned about security. Nomadic communities that moved across the landscape without fixed addresses, without permanent occupations, without the kind of administrative identity that the census could capture. These communities were, in the official language of the time, a threat to public order. The architect of the 1871 law, T.V. Stevens, a member of the Law and Order Commission, said it plainly in his presentation. The special feature of India is the caste system. He meant that crime, like occupation, like social status, could be inherited, that some communities were, by their nature, predisposed to criminal behavior. The law, the official story tells us, was meant to be rehabilitative. Criminal tribes settlements, the enclosed communities where registered families were required to live, were presented as reform programs. The Salvation Army was invited to run many of them. The language was uplift. The practice was enclosure. And the textbook version ends there. But here is what the textbooks say more quietly. The 1871 law was not a response to evidence of criminal activity. It was a response to the 1857 rebellion, to the demonstrated capacity of certain communities to resist colonial rule with organized force. The communities first listed under the Act were not those with the highest crime rates. They were those who had most actively participated in resistance to British authority. T.V. Stevens was not a criminologist, he was an administrator. The data he used to classify communities as hereditary criminals came not from criminal records, but from census data, from the ethnic and caste classifications that the census produced. The census did not cause the act. It provided the infrastructure that made the act possible. Without the census categorizing communities by caste and tribe, there was no mechanism to notify an entire community rather than an individual. The census gave the act its list. And by 1931, 60 years after the first act, the colonial government had listed 237 criminal castes and tribes in the Madras Presidency alone. The law that was presented as a response to crime had become a mechanism for classifying populations. The textbooks tend to remember the justification. They are quieter about the mechanism.
To understand what the Criminal Tribes Act actually did, you have to understand how the census made it possible. The 1871 Census of India was not merely a count, it was a classification project. Every person counted was assigned to a caste, a religion, a tribe, an occupational category. The classification was not neutral. It was built on the assumption that identity in India was fundamentally a matter of inherited group membership. This assumption was in part imposed by the census itself. The anthropometric surveys and ethnographic reports that preceded the census, the systematic effort to catalog the physical and social characteristics of Indian communities, had already created the categories before the counting began. The census did not find the categories, it confirmed them. And once a community was classified in the census, once it had an official name, an official description, an official entry in the colonial database, it could be notified under the Criminal Tribes Act. The notification process was administrative, not judicial. A community did not need to be charged with a crime. A government official needed only to declare that a community was one that has been found to be addicted to the systematic commission of non-bailable offenses. Addicted by community, by birth. Once notified, every adult male member of the community was required to register with the local police. They were issued passes, written permissions to move outside their designated area. Without a pass, presence in any other location was itself an offense. The pass system created a legal trap of extraordinary precision. A man born into a notified community was required to report to the police weekly. If he missed a report, he could be arrested. If he was found outside his designated area without a pass, he could be arrested. If the police decided that his pass was invalid, he could be arrested. He had committed no crime. He was the crime. The settlements where notified communities were required to live were enclosed. Movement was restricted by roll calls, multiple times per day and per night according to records from the Salvation Army settlements of the period. Children were separated from their parents and placed in separate reformatory facilities, not as punishment for an offense, but as administrative prevention of hereditary crime. A child born in a criminal tribe settlement was by definition a hereditary criminal. The settlement was the proof of what they were. The records of their birth inside it were the evidence of what they would become. This is the mechanism the textbooks call rehabilitation. The anthropologist who designed the classification system behind the 1871 Act relied on a concept that European criminology had recently developed, the idea that criminal behavior could be read in physical characteristics, in skull measurements, in body proportions, in physiognomy. The Italian criminologist Cesare Lombroso published his theory of the born criminal in 1876, 5 years after the Indian Act. But the logic was already present in the British colonial application.
inherited criminality, legible in the body, requiring administrative rather than judicial response. You were not tried, you were measured. You were not convicted, you were classified. By 1924, the Act had been amended and expanded 3 times. By 1931, 237 communities in Madras Presidency alone. By 1947, 13 million people in 127 communities were living under its provisions. 13 million people who had never been convicted of any crime, living under a law that said their birth was their conviction.
The Criminal Tribes Act was not a uniquely Indian phenomenon. It was one instance of a global pattern that operated across every major colonial administration of the 19th and early 20th centuries. The use of census-based ethnic and racial classification to create legal categories that assigned inherited criminal status to specific populations. In Australia, the Aboriginal Protection Acts, first passed in Victoria in 1869, 2 years before the Indian Act, gave colonial authorities the power to remove Aboriginal people from their lands, restrict their movement, control their labor, and separate children from their parents. The mechanism was identical to the Indian Act, not individual criminal conviction, but collective administrative classification. In the United States, the vagrancy laws of the post-Reconstruction South targeted formerly enslaved people with a legal category, vagrancy, that criminalized the absence of fixed employment and a fixed address. A black man without a documented employer could be arrested for vagrancy and leased to a plantation as convict labor. The legal category did not name race. It did not need to. The census had already done the classification. In South Africa, the pass laws that would become the foundation of apartheid were being developed in the same decade as the Indian Criminal Tribes Act. The pass system required black South Africans to carry written permission to be in white designated areas. The same pass system, the same administrative logic, applied to a different classified population. The pattern across all these cases is consistent. A census classifies a population by race, caste, tribe, or ethnicity. The classification creates an administrative category. The administrative category is then used as the basis for a legal status that restricts movement, limits opportunity, and presumes criminality, not from evidence, but from membership. The census does not create the discrimination, but it provides the infrastructure that makes systematic discrimination administratively possible. Without a census category, you can discriminate against individuals. With a census category, you can discriminate against a population. The scale changes, the mechanism changes, the discrimination becomes a system. And systems, unlike individual acts of discrimination, persist beyond the intentions of any single administrator. They are maintained by their own institutional logic, by the records they produce, the classifications they reinforce, the administrative categories that outlast the laws that created them. The Criminal Tribes Act was repealed in 1952. The Australian Aboriginal Protection Acts were progressively repealed between the 1960s and 1990s. The South African pass laws were abolished in 1986. The classifications they were built on were not abolished with them. The administrative logic of the census, the idea that a population can be permanently identified by an inherited category, survived every repeal. It is still the operating assumption of every demographic system in the world today.
The repeal of the Criminal Tribes Act in 1952 did not erase what the Act had built. It replaced it. The Habitual Offenders Act of 1952, passed in the same year as the repeal, defined a habitual offender as someone who had been convicted of offenses multiple times and presented a danger to society. In principle, this was an individual standard. In practice, it was applied to the same communities that had been listed under the Criminal Tribes Act. The Act's own language acknowledged this. Former criminal tribes were the primary targets of the new law. The UN Committee on the Elimination of Racial Discrimination noted in 2007 that the Habitual Offenders Act showed no marked departure from the intent of the Criminal Tribes Act. It gave the formerly notified tribes a new name, Denotified tribes, while maintaining the same administrative logic of presumed criminality. The erasure operated through three channels. The first was legal. The 1952 Act replaced the 1871 Act with a nominally different framework that preserved the substantive classification. The communities were denotified, removed from the criminal list, and simultaneously relisted under a new category that maintained the same relationship with police, the same presumption of criminal tendency, the same administrative surveillance. This is documented. Members of denotified communities in India are significantly overrepresented in police custody relative to their population. They are more likely to be arrested without evidence, less likely to be represented by counsel, less likely to have charges against them result in conviction, because the arrests are based on identity, not evidence. The third channel was social. The stigma of the criminal classification, born criminal, hereditary criminal, passed through generations not through law, but through memory. Communities that had been classified as criminal for 80 years accumulated the social consequences of that classification: exclusion from land ownership, from formal employment, from educational institutions, from the kinds of social capital that make administrative rehabilitation meaningful. The law was repealed, the records remained, the stigma remained, the institutional practice remained. Today, approximately 60 million people in India belong to denotified and nomadic tribe communities, the administrative descendants of the 127 communities classified under the Criminal Tribes Act. The National Commission for Denotified, Nomadic, and Semi-Nomadic Tribes recommended in 2008 that 110 million people from these communities receive the same reservations available to scheduled castes and scheduled tribes. The recommendation has not been fully implemented. The census that classified their ancestors in 1871 continues to shape the administrative categories that govern their lives today. Not the same census, not the same law, the same logic.
In Ahmedabad, there is a theater company. It was founded by members of the Chara community, one of the communities classified as a criminal tribe in 1871. The Charas were enclosed in a settlement near Ahmedabad, their movement restricted, their children separated from their parents, their identity legally defined by their ancestry. The settlement no longer exists as a legal structure. The community still lives in the same area, Charanagar, the Chara neighborhood, because the administrative geography of the settlement persisted beyond the settlement itself. The theater company is called Budhan Theater. It was founded in 1998. It performs plays about the experience of the denotified communities, about the police harassment, the presumption of guilt, the inherited stigma of a classification made 150 years ago. One of the plays is about a man arrested on suspicion because a police officer recognized him as Chara. He had done nothing. He was Chara. That was the evidence. The play is based on real cases, many of them. The 1871 census mapped 238 million people. It classified over 200 communities as criminal. The The classification was built into law. The law was expanded for 80 years. The law was repealed. The classification continued under a different name. The communities classified as denotified continued to carry the administrative legacy of a census conducted before any of them were born. Here is the precise mechanism of what happened. A colonial government looked at nomadic communities, communities whose way of life did not include fixed addresses, permanent employment records, the kind of administrative identity that a census could easily capture, and classified the inability to be captured by the census as itself a form of criminality. Not fitting into the administrative system was made evidence of being outside the law. The unmapped were made into criminals for being unmapped, and then the map was used to find them. The Chara actor speaking on stage in Ahmedabad is the descendant of people who were classified as criminals in 1871 not because of what they did, but because of what they were. He stands on a stage and performs that history, because performance is one of the few instruments available to people whose administrative history was written by someone else. The census told them what they were. He is telling a different story. The question is which account the administrative systems of 2025 are reading.